session is Emergence and Scope of Alternative Dispute Redressal Mechanism in Legal Arena. Alternate dispute redressal mechanism. So you mean to say there is an alternative dispute mechanism is coming or emerging in our legal arena. Till this date we are knowing about the judicial system or justice delivery system through courts. That is, rather we can say judicial dispute resolution. The judicial dispute resolution may be knowing national judicial data grid shows that as on this year 2023, about 5 crores of cases are pending in India. We are all well aware about it. About 5 crores of cases are pending before it. It will take another 300 years to dispose of these cases. Another 300 years, think it of how much time. And right to fair, speedy, inexpensive justice is the fundamental right under Article 21 of Indian Constitution. You all are well aware about it. Many of the cases said that right to justice is part of right to life under Article 21. So each and every person must get timely justice. Justice to be in time. Otherwise that is of no use. Justice delayed is justice denied. You all are well aware about it. So what is the alternative for that? There is a lot of thinking going on. Finally, in 1976, the 42nd Amendment already added a provision in the Constitution. You are all aware, Article 39A very clearly says that equal justice and free legal aid. Because economic incapacity should never be a ground for denial of justice. Because persons are not having the capacity to pay money, pay court fee, to engage an advocate, or come to the litigation and spend money, may not get justice. Thereby the person having incapacity, economic incapacity, is always denied justice. To overcome that, a new provision has been added in 1976 by the 42nd Amendment, Article 39A. On the basis of that, they formed a committee in 1980, SILAS, Committee for Implementation of Legal Aid, under the chairmanship of Justice Bhagavati. You might have heard Justice Bhagavati has done a lot for the social justice, and his judgments are all socially, rather you can say that only important social justice is the person at the grassroots level. Such a social impact that judgments were having. V.R. Krishna as well as Justice Bhagavati. Anyway, he was appointed as the chairman of SILAS, Committee for Implementation of Legal Aid Scheme. In between, many cases have come. Hussain Ara Khatun case, M.H. Haskote case, Khatri, Sukhdas, many cases. Ultimately, finally, even the Maneka Gandhi case, they said that fair justice, speedy justice is the right of a person, because the administrative system is supposed to be fair, just and reasonable, it is said. And ultimately, every person have a right to live with human dignity. The basic right a person needs is live with human dignity. So part of human dignity, right to justice is the right of a person. You might have studied the maximum would be just a remedium, isn't it? This is all you studied in the colleges. So ultimately, right is the right is a fundamental right, actually. Right means justice, speedy justice, fair justice, inexpensive justice. So they thought of what to do. Cases are increasing because more the awareness, more the cases. Why? Because normally we know the difference of opinion is everywhere. Without difference of opinion, no society can move. Whenever two persons are there, there will be, because all cannot think together in a same man. Difference of opinion, it is required for the society for progress. And whenever the difference comes, that has to be discussed properly. Then only the difference can be made in a consciousness. Otherwise, that difference become a disagreement. People should having different perspective. According to their perspective, each and every person thinks. Because all are not seeing everything according to their way of thinking or way of presenting. We do things as we are. Because according to our perception only we can see the things. And each and every person has such a perception. The perceptual differences may make the difference of opinion. Difference of opinion is required for progress. There's no doubt in that. All are thinking same way, there won't be any invention, there won't be any discovery. So people should think differently with a different perception. That may go to disagreement. That disagreement to be properly managed. If it is not properly managed, that will become a problem. It will lead to a problem. So you see, a difference of opinion become a disagreement. That will become a problem. If that problem is not properly managed, it will become a dispute. It will become dispute. So you need some other agency or external somebody to get that dispute to be settled. Otherwise, it is very a problem. So if it is not settled in time with the proper way, it will become a conflict. It will raise to the level of a conflict. Once it is raised to the level of a conflict, you have to resolve it immediately. Otherwise, it will spread to caste, it will spread to politics, it will spread to religion, it will spread the society at large, and many agencies may come in a conflict. That conflict to be properly resolved in time. If it is not resolved, it will go to the level of violence. It will lead to the level of violence. That time again, for suppressing the violence, you have to choose the means of coercion. Provision is there in CRPC. Whenever there is an agitation, whenever there is a violence, the collector is declaring 144 prohibition order, and police is using the force to control the violence. It has to be suppressed or not the other way by using force. Even by using force, it cannot be suppressed. It will lead to the level of war. Ultimately, it will lead to the level of war, like Manipur and all. It will go to that level. So you see, a difference of opinion, they are not properly discussed. So that became a disagreement. That disagreement has become a problem. Problem to be managed. If it is not managed, that will become a dispute. Dispute will become a conflict. Conflict will become a violence. Violence will become a war. Here only, why it is happening? There is no proper communication. There may be lack of communication. There may be no communication. There may be improper communication. There may be ineffective communication. So the proper communication between the parties can remove the misunderstanding, can remove the suspicion, can remove the fear in the mind of the person. That may remove the concerns of the persons. So they should be given a chance to communicate each other in a proper way. Allow them to open up their minds. Let them say, let us come know what is their perception, their perception. Their perception, if it is come to know, they can try to manage it. So he thought, by court, the cases are filed on the basis of evidence. The case is decided by a judicial officer. It's a neutral person, there is no doubt in that. But there, people are not getting chance to open up their minds. People are not getting chance to discuss their fear, discuss their concern, discuss their needs, discuss their wants, discuss their hopes. Everything is written in pleading and submitted before the court. He's going through the pleadings and finally going through the proofs or evidence. On the basis of that, he's making a decision. That may not be satisfied. Ultimately, what is justice? What is justice? Justice must give us satisfaction. It's nothing but satisfaction. Many are saying, I have not got justice. Even Soumya's mother says that the Govinda Jami was awarded with life imprisonment. When the journalist asked Soumya's mother, the mother said, I have not got justice. Why? Because she expected that the person to be given death penalty. So what is justice? Justice is nothing but the satisfaction. So court awarded the maximum punishment as according to the procedure established by law, that punishment only to be given. At present, we are reducing. We are coming back to the. We are not giving much hang to or death penalty. We are hanging until we reduce, because reformative theory of punishment we are following. Reform the person. After giving death penalty, we cannot reform the person. The theory which we are applying in India is reformative theory. Anyway, so the thought of doing something, not only reduce the number of cases or reduce the backlog, to bring peace in society. Ultimately, everybody wants peace. Why we are applying law actually? We are applying law because you might have studied the concept of law or purpose of law by Jeremy Bentham as well as Roscoe Pound. Jeremy Bentham says that maximum pressure to maximum people in society. That is the ultimate purpose of law. Roscoe Pound said that maintenance of law and order. Maintenance of law. Actually, through maintenance of law and order, what we are bringing, we are trying to bring discipline. Through discipline, by obedience of law. Right? Through discipline, what we are bringing, trying to bring uniformity in behavior. Uniformity in behavior. Through uniformity in behavior, we are trying to bring progress in society by the proper application of law. Through progress in society, we are looking after the well-being of the people. Through well-being of the people, we are trying to give them welfare. Welfare. Ultimately, our constitution said, Article 38, once you read, you will come to know. The ultimate purpose of this constitution is to make India a welfare state. By looking after the welfare of the people, we can make India a welfare state. So how to make India a welfare state? Ultimately, the people to be satisfied. Which way they can be satisfied? So people are running for justice from pillar to post. Finally, they are not getting justice. Then they thought of doing something. Finally, they got brought an amendment in the CPC in 1999, Section 89 amendment. They added a Section 89. In that, they made ADR, Alternative Dispute Resolution. Not alternative dispute redressal. This method, but that is known as alternative dispute resolution. That is actually now parallel to the legal system functioning in India from 2005 onwards. Alternative dispute resolution has been added. If there is a the court feels that there is an element of settlement in the case, the judge can refer the case for alternative dispute resolution. Which are the alternative dispute resolution? Arbitration, conciliation, mediation, log adalat, and judicial settlement. There are 5 alternative methods. There are many other, but in our Section 89 amendment, they said that there are 5 alternative dispute resolution methods has been brought: arbitration, conciliation, mediation, judicial settlement, and log adalat. For arbitration and conciliation, separate act has been enacted. Arbitration and Conciliation Act 1996. Actually, what is the difference between these? Are just quick, I will say. Arbitration is just like a court practice, court procedure. A neutral arbitrator is appointed with the consent of the parties, and arbitrator is hearing the party, and whatever they want to say, they can say. Once they are coming into an amicable settlement, that settlement can be made. If the parties are not coming to an amicable settlement by themselves, voluntarily, he can make decision. It's just like parallel to the court only. Then why it is set as an ADR? The person appointed to hear the matter is a neutral person appointed by the disputants. They can select a person as an arbitrator. So parties can select a person. Court, we cannot select a judge. Judge is an officer appointed for that purpose. Here arbitrator can be selected by the person. The party can choose an arbitrator. But he is having the power to take a decision. And decision is binding like a civil procedure decree that can be executed, enforced by a court of law. So it is just like a decree it is passing. Conciliation is nothing but the trained conciliation officer is having a proactive role. He can suggest, he can advise, he can somewhat we can persuade the party. He should not pressurize the party. He can persuade the party. He can give advice. Now conciliation is no more. Conciliation has become part of mediation. The latest amendment, Mediation Amendment Act. Anyway, that is conciliation. What is log adalat? Log adalat, there is a separate law has been enacted. You may be knowing Legal Services Authorities Act 1987. This People's Court. This is also alternative dispute resolution. Whatever the cases pending before the court, and not only pending is, a complaint by a person can be brought before the legal service authorities. The bodies were established: National Legal Service Authority, State Legal Service Authority, District Legal Service Authority, Taluk Legal Service Committee, High Court Legal Service Committee, and Supreme Court Legal Service Committee. So these bodies were formed. National Legal Service Authority, State Kerala, it is known as KELSA, Kerala Legal Service, Kerala State Legal Service Authority, State Legal Service Authority, District Legal Service Authority, Taluk Legal Service Committee, High Court Legal Service Committee, and Supreme Court Legal Service Committee. These committees were formed for giving free legal aid to the person those are eligible. Category already made. Conduct log adalat, make legal awareness, and legal aid. 3 purposes. Conduct log adalat. Through log adalat, they are resolving the disputes of the parties. And legal awareness, they are giving classes and awareness to the people in different category of persons from panchayat level to higher level. They are giving legal awareness. And legal aid, free legal aid. Those are not in a position to take up a matter before the court will be given panel of advocates. That until you may be well aware about it. So, free legal aid is given. That is, judicial settlement is a case which is pending before a judge is referred to another judge. And he is hearing the matter and he is making the parties to come to an amicable settlement. That is also having the validity of a order, award passed by the Legal Services Authorities Act, as, like a Logadal. And what is mediation? Mediation is entirely separate. Entirely separate. That is the best form of dispute resolution nowadays discussed all over the world. Actually, a neutral, impartial third party. Facilitate communication, because normally, why the dispute about, earlier I said that lack of communication, no proper communication, miscommunication, no proper communication between the parties. That is the basic reason. They're giving chance to open up their minds by making them to sit in front of a table or opposite each other. Let them say whatever they want. Hear it. Let them negotiate each other, whatever they want to say. If it is done properly, you facilitate them to say what they want. You can ultimately settle the matter voluntarily, and they themselves will suggest, sir, this after hearing, sir, this is the resolution we want. Let them. Mediator has no role. He is not an advisor. He is not a decision maker. He cannot force them. You cannot compel them. It is totally self-determination is the crux of mediation. Whenever the party feel I don't want to continue that, they can quit from the mediation. So till date in India there was no private mediation. We were doing court annexed mediation. That was the status at present, because whatever the case is pending before the case court, it is referred to the mediation. All over India now mediation centers are there under the National Mediation Project Committee is there. Mediation Conciliation Project MCPC. Mediation Conciliation Project Committee under the Supreme Court of India. Every state they formed mediation conciliation centers. Kerala we are having KSMCC, Kerala City Mediation Conciliation Center, functioning at Ernakulam under High Court of Kerala. Every taluk, every district we are having mediation centers established, and whatever the pending cases are referred to, if there is a settlement, there is an element of settlement, judge has to refer as per the order 10, 1A, 1B, 1C. Three provisions are there. Under section 89, they can refer the matter to the court for mediation center by the court, and mediation center they are conducting the mediation. 60 days time is there. If they want, they can extend the time for another 60 days, and the mediator is making the parties sit in the mediation center, both sides of the table, hearing the matter, and finally, once they arrive to a settlement by themselves, that has been written as a mediation settlement agreement, signed by them. If they want their advice of the advocate advice can be taken, and on the basis of that, the mediation settlement is made. A settlement is signed by advocates and the parties. It will be just like Order 23, Rule 3, a compromise decree. What is the status of mediation agreement? If it is asked, you can directly say a compromise decree. A compromise decree under Order 23, Rule 3 of CPC. That is the position. So this has come after three important cases related with the ADR. First case is Salem Bar Association case 1, Salem Bar Association case 2, and Salem Bar Association case 3. Three cases are there that are the base for this mediation and this ADR process. Three cases, important cases. Salem Bar Association 1, Salem Bar Association 2, Salem Bar Association, Afcons case. So Salem Bar Association 2 cases, and the third is Afcons case. Afcons case is the most important case in that they very clearly says which are the cases are fit for mediation, which are the cases are not fit for mediation. If you are interested in the ADR process, just read the judgment in Afcons Infrastructure Limited versus Cherry and Murky. I will tell you the citation, 2010 8 SCC 24. 2010 8 SCC 24, page 24. Afcons Infrastructure Limited and another versus Cherry and Murky Construction Company. Actually, this is the Bible for mediation. This is the Bible for ADR. What are the cases fit? What are the cases not fit? Everything is very clearly written in Afcon's case. You have to go through. You will come to know what is ADR, what is the importance of ADR. Around 30-35 pages are there. The judgment you will easily come to know. Anyway, so in India, private mediation was not there. Singapore Convention, India already signed regarding the mediation, international mediation. We are not ratified. But they said that in private mediation, conciliation and arbitration can be done in private. But mediation, there is no provision. What to do? I think that finally we have come to a conclusion that is very much required. Then only we can take up the matter easily and we can use speedy justice. Otherwise, speedy justice is not possible. So thereby, in 2021, a mediation bill was presented in September. A bill was presented in the Rajya Sabha. That bill was sent for the report of the standing committee. That bill has been sent for the report of the standing committee in December 2021. That time it was known as Mediation Bill 2021. So standing committee submitted its report on 13 July 2022. They submitted its report. What are the requirements? What to do it? That report has been finally taken before the Rajya Sabha on 1st August 2023. This year August, that has been selected, discussed and passed in the Rajya Sabha. That has been sent to Lok Sabha on 7th August 2023. Lok Sabha also passed. It has been sent for the assent of the President. On 14 August 2023, President has given her assent. And 15th August 2023, it has been published in the official gazette. At present, a mediation act has been enacted. At present, a mediation act has been enacted in our country that very clearly says is how mediation to be conducted. That act is having around 65 sections in 11 chapters, having 10 schedules. An act has been made. That act is made applicable. But certain provisions have come on force on 9th October 2023. Certain provisions have come on 9th October. Actually, what was the objective of that act? Objective of the act. Now, till this time, mediators were well experienced, 15 years experienced lawyers were appointed as mediator. The present act doesn't say any such qualification. Anybody can be a mediator. That's it. And other qualification will be made in the rules. Rules are not yet made. Regulations are not yet made. But this act has been made for the purpose of mediation, especially institutional mediation. The purpose is to promote and facilitate mediation, especially institutional mediation, online mediation, pre-litigation mediation, community mediation in a cost-effective and time-bound manner. That is the basic purpose of the new act, which is enacted in 2023, Mediation Act 2023. To promote, facilitate mediation. Mediation means court election mediation will be there continuing. Institutional mediation, private mediation can take up through institution, through service providers. Not only that, online mediation, you can mediate to any person sitting anywhere. When international mediation, the acceptance is not finally set, but that is, rules will be saying how that can be done. Then pre-litigation mediation. Before filing a case before the court, the matter to be sent for mediation. So, if mediation fails, it can now also, compulsory mediation is there. Commercial Court Act 2015 says that compulsory mediation. Before filing the case, it has to go pre-institution mediation. If pre-institution mediation fails, then only the person can file the suit before the court. That is the present status of mediation there. Then community mediation. Every dispute in the community will be discussed in the grassroots level by the person having the knowledge. The Act says that 3 expert persons, those who are philanthropists, interested about the welfare of the people in the community, or knowledgeable persons, or having influence over the persons in the society, to be appointed as the community mediators. 3 persons sitting together and hear the matter and solve the problem there itself. And another 2 important thing is that whenever there is a mediation settlement is enacted or settlement is made, what will be the enforceability? Clearly said in the Act. That will be just like an arbitration award, or that can be made a court decree. If the settlement is made between the parties, that can give the status of a court decree. So whatever the decree passed by the court, the same effect a mediation, a settlement agreement will have. That again the conditions will be laid down by Mediation Council of India. They are going to form a Mediation Council of India for ethics and other guidelines. Establishment is there, Mediation Council of India. So going to establish, just like Bar Council of India, a Mediation Council of India is there. There the mediator can register, they can get accreditation, they can function as a mediator, just like an advocate all over the country. A mediator can work all over the country. Only the name will be registered. Even they say that even a person not registered also can practice. It is said in the act. Anyway, the conditions will be there in the rules and regulation will be there in the rules. So Mediation Act has been enacted. Now every person, whoever is having the interest in mediation to settle the dispute, can become a mediator. Very clearly says that Mediation Council of India is there. Under the Mediation Council of India, they are recognizing the institutional mediation service providers. They can take up the matter. They can mediate the disputes amicably. And conciliation also now become part of mediation. Now conciliation, no more conciliation is there. Conciliation Act, Section 61 to 81 is taken away, repealed. Now that is part of mediation. So mediation will be the future. There is no doubt that the scope will be so high. Not only that, it is not only that, we can bring peace in society, because people are ready to sit together and ready to say what they want according to their needs, according to their interests, according to their hopes. We can their fears can be, their concerns can be addressed, because they are having enough chance to discuss with the parties. You are a neutral third person. You can identify and make them to come to a amicable settlement by themselves, making such an ambience. You are only assisting and facilitating, not making any suggestion or any advice, or not making any settlement. Settlement is by parties themselves. When mediation is not totally concentrated for settlement, mediation is for resolving their disputes, their fears, their concerns, their anguish. So once the matter is, they are having a rethinking, because actually rebuild, redefine, restore relationship is the basic purpose of mediation. Rebuild, redefine, restore relationship. That can be done in a better way by the process of mediation. We're talking about mediation hours together. We can discuss what Santosh sir said, 30 minutes only we are having. Within that time, I said everything related to the mediation. If you have any doubt, you can please ask. Because you all must come in this field, because we want many number of mediators to resolve the dispute which are pending. Think it of 5 crores of cases are pending. It can be resolved this type of ADR only, and most important aspects comes in mediation, because there the emotions, the feelings, the fear, the anguish, the concerns, the needs, the wants, the interests, everything can be addressed. Even the cases and problems which are not brought before the court, any complaint or any concern connected with that also can be brought in mediation and discussed, and finally that also will be settled with their consent, consent. That is the beauty of mediation. When connected matters also can be brought in. For family cases, this is one of the best alternatives. There is no doubt that this is one of the best mechanism and best method. First, for that we have to build mediation as a culture. Instead of fighting each other, instead of going for a legal battle, why not to go to the mediator and find like going to a psychologist or a counselor? Whenever there is dispute comes, you can straight away say yes. Why not to go to a mediator and solve our dispute? That culture should come. It will be coming. There is no doubt that ultimately peace is everything. Peacemaking is the ultimate purpose. Quiet revolution is coming. Peace is the most powerful weapon of the mankind. War cannot help. Peace only can help. There is no doubt in that. Please.